Okay, I just want to make sure that the court reporter can hear me okay, and the board members.
I can hear you.
I'm calling the meeting to order. My name is Tom Sunderman. I'm the vice chairman. I would like to. Do we want to bring Tim in? Yeah, Tim, Mr. Voss, the chairman of the board, would like to make a statement.
Yeah, I am on the road back from a unexpectedly extended trip to Chicago, and given my limited capacity, I can hear and question, and I can participate, but I can't manage a meeting. So I've asked Vice Chair Sunderman to chair this meeting, and I'll turn it over to him.
Thank you very much, Mr. Voss. I'd like to open the meeting with a statement. Good afternoon. My name is Tom Sunderman. I'm the vice chair of the Historic Conservation Board. I'd like to take a minute to remind everyone about the rules of this proceeding. This proceeding is at all times covered by the rules of procedure adopted by the board on September 26, 2011, amended March 23rd, 2015, last amended March 9th, 2020. Copy of the rules of the procedure is available for review online. All those planning to testify, which does not include those solely making arguments, such as attorneys, will be sworn in before their testimony. This is a quasi-judicial hearing. As such, the board reserves the right to deliberate in private. The Ohio rules of evidence do not apply to this hearing. However, professional rules of conduct do apply, and candor to the tribunal is required. The board members are citizen volunteers and are not paid for their service. They are treated as public officials under Ohio law. Any attempt to influence them, including but not limited to bribery, intimidation, retaliation, which may include contacting their employer in an attempt to exert influence, is punishable as a crime. All should be aware that this meeting is being tape recorded. Therefore, speak clearly into your microphone and state your name and address for the record. In the event of any technical difficulties with the video conferencing technology, I may continue or postpone this hearing at my discretion. All participants providing testimony must have both camera and audio features turned on in order to participate. With that said, let's go to the first item, which is our only item on the agenda today. Mr. Owen, would you like to lead us in that discussion?
Thank you, Mr. Vice Chair. This is the continuation of the case from June 27th for new construction at 2000 Dunlop Street. Just to give a brief overview as a reminder of what we were discussing in the last hearing. This is a proposal for new infill construction for a 44-unit building at 2000 Dunlop Street in the Over the Rhine Historic District. The applicant is requesting zoning relief in the form of density variance to allow a density of 220 square feet of lot area per unit, and also a rear yard setback variance for 10 feet for the rear yard. This is this portion at the rear of the building here. And then the applicant is also requesting a certificate of appropriateness for the new construction of a 4-story building at 2000 Dunlop Street. Sorry, I realized I wasn't actually sharing that. So here's the setback variance area, the 10 feet at the rear L portion of the building. So as staff presented the staff report at the last hearing, I'm not going to go through that again, just a reminder of what is requested, and the staff recommendations are to approve the variance to allow the proposed density of 227 square feet of land area per unit for a unit count of 44 units. We also recommend approval of the variance of 10 feet for a 0 lot line on the rear portion of the lot. And staff is also recommending approval of the certificate of appropriateness. I did not include the addendum that was presented at the last hearing on that. You can see that on your screen now. There was a typo in the recommendation. So staff is recommending approval of the application for a certificate of appropriateness for the proposed new construction at 2000 Dunlap Street, with the following condition: that the building permits must be issued within 2 years of the decision date, or the COA shall expire.
Thank you very much. Before we go on, I do need to ask the board, I need a motion to suspend the rules so that I can be the chairman, even though Mr. Voss is on, he's in his car. But we need a motion to suspend the rules so I can do this. Do I have a motion?
I will move.
Okay. Do I have a second? All in favor, say aye.
Aye.
Thank you very much. Now, we have witnesses. Mr. Suter, you go first. We have a question here, a motion to reconsider. The question is, do we want to consider whether or not this is transitional housing or congregate housing?
And I'm glad to.
Wait a minute, hold on. Okay, Mr. Finney, are you here?
Present.
Okay, would you like to explain that to us?
Yes. So this has kind of been finessed, I believe, by the applicant up until now very effectively. But what they have said is simply not true. And so what I mean by that is that, first of all, part of the application necessarily is a use variance to allow for congregate housing at this location. Transitional housing at this location. And presently, we think this use is transitional housing. They have told you entirely incorrectly that there has been a determination by somebody prior to getting here that in fact it is congregate housing, which it is not. And in fact, no such decision has ever been made. And I'll say that in several ways. First of all, the letter that has been presented to you as that decision doesn't say anything about a determination. It simply says that the zoning category is X. It doesn't say whether this use does or does not fit within that categorization. There is no such. Secondly, the Planning Commission and its staff can only act through written decisions, because we would have nothing to appeal if they made a bad decision. There's never been a written decision. We've, at least to my knowledge, we've explored this extensively and have not been able to identify any written decision that says it is in fact transitional housing. So, and then finally, you already have received significant testimony about the use of the property, and every single letter that we have in support and dozens of witnesses that are going to appear in front of you want to testify about this use. And the only questioning and the only testimony you're excluding is that which would contest that as an appropriate use of the property. So for all of those reasons, the motion to reconsider should be granted. I should be allowed to question their witnesses on what the use is to show that in fact it is transitional housing, and that either that's not permitted or it's a requirement that they ask for a variance for that use. And the exclusion of that testimony is greatly prejudicial to us on a decision that has never been issued, a decision that is not appealable, and a decision as to the use that is incorrect. Thank you.
Thank you very much. Mr. Suter, would you like to give your side of that argument?
Thank you, Mr. Chairman. I appreciate that. There is no use variance here. Use variance is a technical term. It's allowed in the zoning code if it's applied for. So there is absolutely no use variance at issue here, and it has not been applied for. We applied for a certificate of appropriateness and 2 variances stating that it's congregate housing. The city determined that it was a perfected application, which means that they agree that it's congregate housing. You can ask Miss A House, who's the zoning administrator. She's, I think, present. Welcome to ask her about her determination that it's congregate housing, or she wouldn't have perfected this application. That's really the determination that needed to be appealed. It was not appealed. And it's really not a question of whether the board wants to hear issues of use. It's really a question of whether the board has the authority and the power to do so. And if the board turns its attention to the administrative code of Cincinnati, Article XXX, Article 30, Section 4, your powers are very limited. Limited to determinations of certificates of appropriateness and other matters of historic preservation under the Cincinnati zoning code, not determinations about use or appeals relative to use. So it would not even be within your authority to hear this matter. This should have been appealed when there was a determination that the application was perfected. And so the motion for reconsideration should be denied like it was the first time it was made. And we should move on with the very narrow issues before the board. Thank you.
Thank you very much.
If I could be heard on that, on those issues.
I'm sorry, who's speaking?
Christopher Finney.
Oh, Mr. Finney, you, okay.
Okay, two things. First of all, the use and the appropriateness of the use is part of the application process for the certificate of appropriateness. That's one of the considerations that the panel has. Secondly, I would love for you to ask Mr. Suter or Ms. A House or anyone else where the written decision is that was issued that we could have appealed relative to this claimed use. And then I will tell you that if that decision was made, it's entirely incorrect. And this would be the panel, as we argued in our motion, to hear the appeal of that. So, but there, you know, and Mr. Weiss would be very familiar with this, maybe some of you others would as well, that an appeal right and an appeal deadline triggers off of a written decision. And please ask what written decision was issued that this is in fact congregate housing, because both the standard that was enunciated orally previously is incorrect, and to our knowledge, that decision never has been issued. That is simply not correct. I would love to get to the bottom of that.
Okay. Do I have a motion from a member of the board?
Mr. Chair,
Yes.
Charles, could you weigh in on this a little bit? Personally, I don't know. In my opinion, and I'm not an attorney, that the board wants to be involved in the nuances on determining use classifications. I think I'm of the opinion we assume the application is correct and sincere and honest. And if in fact it turns out to be not the case, then that sounds like a case for further court. I don't know. Do you have any thoughts on this?
Mr. Zalesko, I think if you're soliciting legal advice, I would recommend maybe proffering a motion to move to private deliberation to deliberate on an issue rather than advising you on the nuances in the meeting, open meeting.
I would like to make a motion, Mr. Vice Chair, to move into executive session.
We have a motion to go into executive session
I'll second
or
that.
private deliberation. I'll call the roll. Mr. Zalesko,
Aye.
Mr. Voss, Mr. Weiss,
Yes.
Ms. Smith, not present, Ms. McKenzie,
Aye.
Vice Chairman votes aye, so we will be going into executive session. Please stand by. We will be back soon.
Okay, I'm gonna put everybody in the waiting room one by one, and then when they return, everybody will be let back in. And then anybody that's on YouTube, just refresh your browser, and when we go